cooperation, and so great job. And today's over now. You know, I'm sure that you're going to be preparing more this evening, so I don't want to make these remarks too long. You were told to keep our remarks in total under 10 minutes. You can get our specific comments on the comment sheet, obviously, but I just want to go through a few things that I thought were important. Just a couple things on sort of polishing things up, cleaning things up. I think that, I know it's early in the season, and so it's okay. You're kind of, you know, getting yourself rounding into mid-season form, you know, so some of these things will get cleaned up, but just, you know, so you hear me say them, don't make that objection on Rule 6-15 unless you're sure, you know, the whole, who can be a party representative. Make sure that once you've entered something into evidence, you give a copy to the jury and the bench. I mean, if you have to make like 17 copies just so that you know you have enough, do that. But you know, you should never be like, oh wait, where's a copy? There should be one for you and every member of your team, one for co-counsel if they want it, one for the jury, a couple for the jury, one for the judge. I mean, you get what I'm saying. And you know, it would help if you're going to mark it as Exhibit 1 or Exhibit 2 that you actually mark it as Exhibit 1 or Exhibit 2. Because a couple times people were like, can I retrieve Exhibit 2? And I was like, I don't know which one Exhibit 2 is. I forget now. So, I mean, we would have a court reporter in a real trial, and the court reporter or the, you know, court administrator, or, you know, it would be someone's job to put a sticker on it once it actually goes into evidence. But since we don't have that, it's on you guys to keep that organized. And so that's just in the manner of like execution. Let's see. Character. I want to talk about character. First of all, I want to say that don't take any of my rulings personally. You know, I'm not a judge. I'm a law clerk at the Court of Appeals for Veterans Claims here in town. I did mock trial through, you know, 4 years of college, and I've been judging since then. And I have a lot of fun doing it. But I'm not a judge. So, you know, what's more important to us as scorers is to hear you argue and to hear the force of your arguments. And I think on character, there were some opportunities missed on both sides. On hearsay, there were some opportunities missed on both sides. I think, I read 404 as saying that the defendant in a criminal case can offer evidence of pertinent traits of character. So, you know, that whole action in conformity therewith rule doesn't apply to the defendant in a criminal case. Maybe I'm reading 404 wrong. But you guys should have a good grasp on that. And also this notice of intent to offer character evidence. That should be one of the first things out of your mouth when someone claims that you're trying to offer character of the defendant. Well, yes, Your Honor, but we agreed that we could. Maybe I'm getting that wrong. My colleague who more recently than I took the bar can maybe help out with that.
He's right.
Yeah, so anyway, just keep that in mind with character evidence. It seems to me that the other thing we were talking about was if character is an issue in the case. Oh, do we have a blue sheet question?
Yes. I think Deborah
is missing some scores at the top, so he said fill out whatever's highlighted.
We'll wait on it. Okay, just a couple more things. Hearsay, I think that you have to brush up on your hearsay rules and exceptions and know when your argument is that it's an exception to hearsay and when your argument is it's not hearsay. If you're arguing that it's not being offered for the truth of the matter, that's not an exception to hearsay, that's just not hearsay, you know? There was a lot of stuff here that I thought that could have been the first thing out of someone's mouth when someone else made a hearsay objection. So just understand, like, you know, am I asking this because we really care whether the officer did want $200,000? No, I'm offering it to show that the listener heard that and you know, that's what she believed and that's relevant for some particular reason. And you should what it is that it's relevant for, because that's always going to be the next thing. Well, if it's not offered for the truth, then why is it relevant? So that, it kind of sometimes proceeds that way. So I would just look into that and, you know, brush up on that. Everyone could slow down, I thought. There were times in every examination and every witness statement when I thought that you could slow down more than you were. And I think a lot of it is nerves, a lot of it is, you know, not 100% perfect grasp of, you know, your memorization, whatever it is. Just, you know, keep it nice and slow, keep the pace slow. We're trying to keep up with comments and what's being said, and for me, with objections too. So the more you can slow it down, the more you can repeat what a witness just said in your next question to re-emphasize the points that are clear to you, but we're just hearing this for the first or second time. That really helps. I read tarot readers, by the way, the expert one, as not necessarily saying that it has to be peer-reviewed and that it has to be subjected to any particular kind of testing, but that the judge should consider, among other factors, whether it has been peer-reviewed and other things like that. So I don't view that as a requirement. Judges should consider, among other factors, whether the theory or technique has been or can be tested, whether it has been subjected to peer review, any of it. So, you know, little things, little kind of adjustments on your arguments, things like that. The defendant, you had a time issue. I know it wasn't your fault, but it was your fault, or it was both of your faults, you know, because you left her with not a whole lot of time. And I really like this witness. You know, the third witness. But I like John Cross. It was tough on direct because you had to sort of speed through stuff. And, you know, so that's, you guys got to work that out. And I don't know, maybe put the defendant first if that's your most important witness. But you really should not be anywhere close to running out of time. I mean, it's far better, I think, to say fewer things and not be anywhere close to running out of time and have a good presentation than have to do what you guys went through. On the other side, I thought it was a good cross, but you maybe missed an opportunity to hoist them by their own petard by giving them lots of extra time to have her tell her story. I thought that you might think strategically next time, if that happens again to an opponent, about keeping your cross kind of short, with like a few short, direct pointed questions, because you were asking some really good questions. You had good points you wanted to make, but because of that, she got a chance to like get her character out there and her story out there through the cross. So that's just a strategic thing. I don't necessarily like ding you for that. It's just a thing to consider. But anyway, those are my thoughts. I thought by and large you did a great job. You know, good luck in the next couple rounds. And if you have any more questions for me afterwards, feel free to come.
All right, guys. Yeah, well done, everybody. I quite enjoyed the performance. So this is actually, I suppose, full disclosure, my first mock trial tournament, which I have judged at, or even attended. I did moot court in law school. I did 7 years of policy debate, so I didn't really mind the speed as much. I do want to second the point that everyone could probably slow down just a little bit. I was fine with it, but there are other judges who I think could have gotten pretty easily like lost in, especially the witness questioning aspect of it. I think that everybody did really well in terms of time management on opening and closing statements, so that was fine. Just sort of apply the same technique into your questionings. As for specific points, there was one other point that I want to add on the substantive evidence law, which was I think somebody like misstated or like misapplied present sense impression at one point. I don't remember what it was for. I just like wrote down present sense impression, that's wrong, on my notepad, and I can't remember why. But let's see, other than that, is your accent real?
Mine?
Yes.
No.
Okay, so that you kept up the accent when you ducked in here to tell us how much time we had left. Props, that was great.
Thank you.
I also really, really loved film noir and Rand Casino Diva as an interpretation of the character. That was really cool. So let's see.
Wait till I have more time.
Yeah, well, and I also want to second the point that he made about, so when you had all that extra time in cross, that you got enough of your story out around the questions that you had to answer as well. That was pretty well done. So, let's see. I'm trying to think of any other really specific points here.
One other thing I forgot, I'm sorry. Rule 704, in general, an opinion is not objectionable just because it embraces an ultimate issue. So you'll get that right next time. That's why we do these.
Yeah.
Oh, a quick question in regards to that.
Yeah.
Right underneath in the Nichols, it says an exception regarding an expert opinion. I think that's where we all got confused.
Well, right, so that's kind of the Hinckley
Yeah.
rule, right? Like, you know, the guy who shot Reagan, like, an expert can't say, well, this guy, in my opinion, had or had not the mental state. But I'm not sure we were getting to that opinion. I think the opinion was something like, was it a bribe? But, I mean, so I don't, but that's a good point. Anyway.
So, one, and this might just be like some stylistic aspect of the activity that I don't get, but when you're delivering a closing statement, like, he's not a member of the jury. I mean, I know he has a ballot to fill out, but like, you know, don't direct it generally halfway between the jury box and the bench, because, I mean, I think at one point you were explaining how preponderance of the evidence works to a judge, which seems kind of unnecessary. I mean, I think that your content and your style was fantastic, but that everybody, and this is both closing statements, I think kind of did this, like ended up splitting their attention halfway between the two of us, and it got a lot more difficult for me to follow along what exactly was being said substantively whenever I am like, just, nope, stop, nope, look at me, sorry, damn it. So, yeah, that was basically my thought there. What happened to the other $50,000? Does anybody know? The napkin says 250 and there's only 200 in the briefcase.
So if we didn't have enough time, part of it is she and Covington gamble while they're doing the bribe.
Oh, when they were playing
They
blackjack,
lose.
okay.
They play poorly and lose $50,000.
Okay.
But it wasn't able to come out, and she wasn't able to get it out on cross either.
Oh, one other point. So in your closing statement, I think also in the opening statement, you both make reference to this new police chief's email, which is never in evidence.
Yeah.
Yeah.
Time concerns would also probably come in under memoriam.
Yeah. In the future, I would recommend not putting that in your closing statement.
Okay.
Yeah. Like, I mean, if it's not in evidence, basically, you probably shouldn't talk about it in your closing. I mean, I'm not a trial lawyer, but, you know, that's my impression of it at least. And I think that's about it, other than I get specific comments in here. If anybody wants to ask me, I'm going to be judging tomorrow as well, so I'll be like wandering around the building. Feel free to walk up and say hi, ask me some questions. But, yeah.
I thought all of you were good, and you do all the things that, I mean, your recall of the facts and the story was really strong overall. I mean, there's a reason that I don't do litigation, and that's part of it. But, so the flow was good. I kept getting distracted about whether what you were trying, particularly for the defense, whether you were trying to defend against and sort of a conclusion that the defendant was inclined to take bribes, or whether she actually took one. And maybe that's maybe I didn't understand what it was you're trying to prove, or disprove. But it seemed there was a lot of focus on that as opposed to creating doubt about whether she'd actually taken the bribe. And so, for what that's worth. Does that make sense? Do you know what I'm saying?
Well, we have to be clear about proving that I did give a bribe, but that I was coerced to do so. So we have to be clear about that.
But even so, though, I think I don't mean whether you took it. I mean whether you were inclined to take it, or whether you were pressured, and whether you would have been inclined. I still think are two separate questions. I mean, somebody can be inclined, because I've seen this, somebody can be inclined to do something, but not necessarily sort of feel pressured in a particular situation to react a certain way. So that's just something to be aware of. But that's
Yeah,
Good.
great job, guys, and
I'm sorry, did you guys introduce yourselves or did I miss that?
oh, well, I'm Tom Duncombe, Court of Appeals and Veterans Claims. Yeah, I live in town. Yeah, that's it.
Yeah, I'm Kevin Bell. I recently graduated from NYU, took the bar exam. I'm now working in a fellowship with the Administrative Conference of the United States, which is the smallest agency in government. We have a permanent staff of 14, I believe. But yeah, we're a whole real agency, and we mostly do administrative
Still want to
procedure.
eliminate that agency.
You know, we got defunded for like 15 years, and recently resurrected in 2010. So, yeah, no, our new chairman, Paul Verkeel, recently retired as well, so we're rudderless and leaderless and all distraught and estranged. Oh well. But yeah, like I said, I did debate, and I've done a lot of oral advocacy stuff before. This was fun though. I guess had not thought about how much of it was theatrics as opposed to like knowledge of law and advocacy, so that was fun.
I'm Deborah Wolf. I graduated from UVA in 1987. I'm an attorney with the Food and Drug Administration, and I've been there a really long time. And so this was fun.
Can we go up to you for individual comments?
Oh, yeah, I'll be around.
Yeah, I mean, I'm good right